Hi everyone, on today's video, since this will be our last video of the year, I want to talk about a few things that happened recently that might impact you, including the new COVID relief bill, a DACA case in Texas, and holiday slowdowns at USCIS. My name is Mejer. I'm an immigration attorney in New Jersey who has clients all over the US and in other parts of the world. I was an immigrant who came to the US as a child. My family was the victim of immigration fraud, and it took me over 2 decades to become a US citizen. My goal is to help people like me so they don't have the same stress and frustration that my family had in achieving our immigration dreams. If you're struggling to get the status you want, call us. We've often been able to help clients who were referred by other attorneys when the other attorney said they couldn't do anything more. On Tuesday, December 22nd, Congress, that's both the House and the Senate, passed the newest COVID relief bill. It was the longest bill Congress has ever passed at 5,593 pages. There were 2 parts to the bill, 2 main parts. One was to provide relief for COVID. That means a stimulus check for 80% of people in the US. Yes, including this time families who have a member who is an immigrant and not a US citizen, as well as some other items such as federal unemployment benefits on top of state benefits, rent assistance, and money to distribute the vaccine. The other and much larger part of the bill funds the government through September 2021. There were also some tax cuts and increases for military spending. After Congress stayed in session, long hours to try to get this passed, on Tuesday evening, President Trump released a video saying if Congress didn't increase the stimulus payments from $600 to $2,000, he might veto the bill. Trump refused to participate in any of the negotiations for the bill. If Trump vetoes the bill, Congress does have the votes to override that, but time is running out. The Democrats have suggested that the House can pass a standalone bill for $2,000 for 2,000 stimulus payments. That still hasn't happened yet, but it might later on today or even tomorrow. So if that changes, we will do our best to update you right away. One part of the bill that immigrants are happy to hear about is the part that allows for families with members who aren't documented to receive relief. If you recall, we talked about this back in the spring when the CARES Act did not allow for anyone who was undocumented or had an undocumented household member to get a stimulus check. If there was a family member who was undocumented, the entire family was left out from getting stimulus payment. In this new agreement, U.S. citizens and green card holders will be able to get $600 in aid even if they filed a joint tax return with an undocumented person using an ITIN, individual tax identification number. They will also get an additional $600 for each dependent child. So a family of 4 could receive $2,400. The better news is that this new bill also allows those in the category with a Social Security number to receive a check for $1,200 per household and $500 per child that they missed in the previous stimulus payment. So not only can you get the new one, you can also get the old one. If you're undocumented and don't have a Social Security number, unfortunately, you'll still not be able to receive a stimulus check. Even if you have an ITIN, individual tax identification number, and you pay your taxes every year, it has to be a Social Security number. Even if you have a U.S. citizen child, if you don't have a Social Security number, you won't get check, period. If you file for taxes yearly with ITIN and qualify for DACA, but for some reason you haven't filed for DACA, do so now. With DACA, you get employment authorization and a Social Security number. Even if you don't get a stimulus check, you will be able to get the payment when you file for taxes with the Social Security number. Now, I've talked about DACA and advanced parole a lot this year, and based on recent court decisions, I've recommended that anyone who is eligible for either of the two get their applications for both as soon as possible. You probably heard in the news that there's a case in Texas that might impact DACA. Andrew Hanen is a judge in the U.S. District Court for the Southern District of Texas. Judge Hanen was appointed by President Bush, is very conservative, and a Trump supporter. In the past, Judge Hanen has said that DACA is likely illegal. Texas and other GOP-led states began this lawsuit in 2018 and asked for the judge to stop new DACA applications from being accepted and to bar renewals and to eventually end the program, saying it placed an excessive financial burden on the states. You're probably saying to yourself, wait, didn't the judge in New York just say that DACA could continue and had to accept new applications? Yes, he did. But, and there's always a but, this lawsuit is in Texas and is based on a different argument. Rather than asking if Trump can end DACA, this lawsuit asks the judge to decide if Obama put it in place legally. And by the way, he didn't. In 2015, Hanen blocked the Obama administration from expanding DACA eligibility and starting a new program called DAPA, which was to provide deportation relief to parents of Dreamers. This lawsuit was filed after the Trump administration attempted to wind down DACA, which was stopped by several courts. Again, it's how they did it, not whether they had the authority to do it. Because the Trump administration and the Justice Department refused to defend against this lawsuit against DACA, the Mexican American Legal Defense and Education Fund, as well as the state of New Jersey, intervened in the case and have been arguing for DACA to be upheld. In late August 2018, in response to a preliminary injunction, that's a request to stop DACA from continuing, Hanen issued a strongly worded 115-page opinion saying that those trying to end DACA had shown they were clearly likely to win. He said that DACA was contrary to federal law and that the Obama administration appeared to have violated the Administrative Procedures Act because they implemented DACA through a memo rather than a rulemaking process with public comments. And by the way, we know this argument works because that was the basis by why the Supreme Court of the United States said Trump could not remove DACA because they did it by memo instead of the rulemaking process. Now, this lawsuit can be fixed, but this lawsuit brings an issue that I think is accurate. The way DACA was implemented was not correct, just like the way DACA was ended was also not correct. However, Judge Andrew Hanen didn't end the program because he said that Texas and the other states had waited too long, 6 years, to ask for a preliminary injunction. Arguments were heard by the judge from both sides on December 22nd, 2020. We don't know how or when the judge will rule, but we'll be sure to let you know as soon as we find out anything more. Now, if President-elect Biden was president tomorrow, he could enact DACA through a rule-making process and thereby make the lawsuit moot on that issue. And that is likely what he will do if there isn't some kind of other reform. And he could also bring back DAPA that Judge Andrew Hanen closed and prevented from being implemented the same way. Let's move on. Holiday slowdowns for immigration processing. I'm sure you're all aware how slow USCIS is in a normal year. Add in COVID and we've had anything but a normal year. In the past, people would submit their application and get biometrics, that's to get your fingerprints and background check. So they would submit their application, get biometrics appointment notification within about a month of their application being accepted by USCIS. This is an important step in the process because USCIS wants you to have a background check done before they will agree to process your application. Now we are seeing people aren't getting their biometrics appointments for 5 or 6 months or longer after USCIS says their application was received, depending on where in the country you are and what office you filed your application with. USCIS has delays in processing the initial acceptance of cases, putting them in the computer and mailing out receipt notices. Processing times across the board have also increased. Now, this always happens during the holidays, but it increased this year due to COVID. If you go to USCIS website, you can check the processing times for each type of application and for each processing center. In particular, the processing center where your application was filed. Now, we'll put a link so that you can check your case. Just take a look below. We also have a video about how to check your case status, which I'll link also below. But you can't use this without a receipt, meaning you can't check your legal status unless you've gotten a receipt from the government. The reason you want to be aware of the processing times on their website is that often people ask what they can do since USCIS is taking so long to process their case. If your case is taking longer than the processing times listed, you can ask an office to submit a case query or service request for you by calling the 1-800 number. Also, there is a lawsuit you can file called a mandamus action that we have used to speed up getting a decision on your application. The question becomes what's reasonable, and what's reasonable in COVID? Well, that's a good question. It's not clear. It depends on the application. Now let me just give you some processing times that are current now in December 2020. First, the form I-129F, that's the fiancé petition. At the Vermont Center, it's taken 18.5 to 21.5 months. This is more than double what it was at the beginning of the year, 4 to 6 months, close to triple. I-130, for a family-based petition being processed, it varies depending on your preference category, such if you are the spouse of a U.S. citizen, or whether you're a green card holder, or a child, or parent, what have you. We recommend that you look for your category to know how long it might take for you. In Nebraska, I-130 is taking 7.5 to 9.5 months for every preference category. In Potomac, it varies for the preference category, but it ranges from 1 week, imagine that, to 11 months. In Texas, it's 9.5 to 11 months for most categories. California, which decides many of the I-130 applications, is even more backed up. If you're a U.S. citizen applying for unmarried children over 21, the wait is over 4 years long. If you're filing for a brother or sister, it is up to 9 years. Now, we'll give you a few examples for the I-485. That's the change of status. That's when you're applying to become a lawful permanent resident, a green card holder. Vermont is taking over 19 months to almost 3 years. We help clients all over the U.S., but those that have their application processing in Mount Laurel, the office closest to our main office in Eatontown, that processing time is 10 to 18 months. So a year to a year and a half. We've had some people say in comments that they haven't gotten their work authorization yet. You can check the processing time for that as well. At the National Benefit Center, they are currently processing applications from June 2020. So it is almost 6 months to get work authorization. At Vermont Service Center, it's 4.5 to 6 months for most, although some foreign types is taking over 14 months. That's over a year for work authorization. At Potomac, 3.5 to 5.5 months. For removing conditions on your green card, that's petition I-751, when you have a green card of only 2 years, it's taking Vermont 10 to 16 months. For those applying for citizenship, we look at the times at the Miami field office, since that historically is one of the slowest in the country. You want to look at the field office processing your application to get an idea of how long it will take you. However, for Miami, it's taking 8.5 to 18.5 months. So between a year to year and a half. With all that information, I hope it helps you understand why it's important to get your application filed ASAP. When your application is received by USCIS, it is given a priority date. That is the date the application was received by USCIS, and when you check the processing times, that is the date you look at to determine if or when your papers are close to being processed. What are they looking at, and what's your priority date? And that's how you see the difference. Have you ever gone to a store, maybe to get your driver's license, and they give you, or maybe to a supermarket to get cold cuts, and they give you a number to hold your place in line? This is what your priority date is. And the sooner you get your number, the sooner you get in line, the sooner you get your application in, the better you are for getting your application processed quickly. If you want to be up to date on US immigration, be sure to like our videos when you watch them, as they help others to see them. Subscribe to our page, and if you are on YouTube, hit the bell so that you'll get a notification of any new videos we upload. If you found value in this video, please share it with others. It means the world to us. We appreciate your comments and your support. Happy New Year. We hope it's a better one for all of us than 2020 was. Stay healthy and be well.